Hello, everyone, and welcome to the series of judicial forums. The justice we want depends on the judges we choose. I am Liz Elliott. I'm the co-chair of the New Orleans Safety and Justice Challenge Community Advisory Group. And I want to thank you for tuning in. And thank you to all of our co-hosting organizations, Court Watch Nola, Innocence Project New Orleans, SPLC Action Fund, Louisiana Courts Matter, National Council of Jewish Women, League of Women Voters, Orleans Public Defender's Office, Crescent City Media Group, Urban League of Louisiana, and of course, we want to thank our moderator, who this evening is Mike Perlstein from WWL. At this point, I'm going to turn it over to him and our candidates, Lon Burns and Nandi Campbell, for Section G of Criminal District Court.
Very good. Thank you so much. And let us just start by, there we go, we'll start the video. Good. Let's just start by having, we have two candidates for Section G in alphabetical order, B before C. Let's have Lon Burns. Why don't you start with a brief introduction of your legal experience and your candidacy.
Thank you, Mike, and good evening. Liz, I want to thank you and the New Orleans Safety and Justice Challenge Community Advisory Group for hosting this event and giving me this opportunity to present myself yet again to the public. Most of you know me. My name is Lionel Burns. I'm born and raised here in New Orleans. I have 22 years of experience in criminal law at Tulane and Broad. As a former prosecutor, I prosecuted successfully 167 jury trials, 85 judge trials, with a 97% conviction rate. Or you may know me from some of my work as a private attorney, where I represented Natasha Allen, whose son was killed by the New Orleans police, or the case in which I represented Chelsea Thornton, a young mother with mental illness who unfortunately murdered her 2 children, but was found not guilty by reason of insanity, and awaits immediate group home placement any day now. Or you know me from the thousands of cases that I have represented you and your family on here in Orleans Parish. Today I stand ready, having worked both sides of the aisle at Tulane and Broad. I stand ready to be elevated to the next progression, and that's Criminal District Court Judge, Section G, with your vote. Thank you.
Thank you, Mr. Burns. And now we go to Nandi Campbell.
Good evening. My name is Nandi Campbell. I'm originally from Brooklyn, New York, but I chose to live in New Orleans. I chose to live in New Orleans after going to law school at the age of 33. And I went to law school not to become a lawyer, but to become a public defender, because I was really interested in how this criminal justice system could progress along so long, the way it disproportionately affects African-American communities and African-American young men. After moving to New Orleans, I was a public defender for a year before I went out on my own and opened my own business, sticking to criminal defense, always just criminal defense. The reason I'm running for judge is because in 12 years of being in Tulane and Broad, I observed something that bothered me. I observed judges who are passive and judges who did not feel like they had an obligation to work to the system to make it a better system. The reason I'm because I am tired of systematic racism applied only to African-American communities and people sitting back and allowing it to happen over and over again. And so the reason I'm running is because I want to stop doing what we have been doing, because we know it doesn't work. And the reason we know it doesn't work is because New Orleans continue to have a crime problem and it continues to keep residents unsafe, but we also incarcerate so many people. And so I want to be a judge because I want to reform the system. I want to be an active judge and ensure that the system works for everybody and not just for a few.
Well, excellent. And then as we launch into the questions, we'll start with some of the questions provided. The answer should be around that 2-minute mark of your opening statements. And once again, let's just, thank all of the hosts, all the nonprofits, of course, both candidates, and most importantly, all of the people checking this out either live or later on Facebook for what really is a momentous time in the history of this country, number one. And at the center of these really game-changing times is the criminal justice system. So let's start with, we've seen the issues of systemic racism raised in so many forms, obviously tragically with the murder of George Floyd, and it's sparked what has been simmering, as we know, for a long time. So let's again start with Lon on this. What do you think the courts can do to reduce obvious racial and ethnic disparities in treatment by the court system?
First of all, Mike, let's understand that as criminal district court judge in Section G, as the judge, I am not responsible for who appears before me. Article 61 of the Louisiana Code of Criminal Procedure provides that the district attorney brings charges against persons who appear in court, and they appear there based upon either a bill of information or a bill of indictment. So understanding that, one, the court is not responsible for who appears before it, but what can the court do? The court can decide if Black young men who appear before me suffer from mental illness, if Black men who appear before me are either nonviolent or violent offenders, do they suffer from mental illness? And then as the judge in Section G, what I'm going to do, I'm going to have specialty courts. I'm going to have a court that's going to address mental health. I'm going to have a court that's going to address homelessness. I'm going to have a specific court, Mike. And remember, Lionel Lyon Burns said this first. I'm going to have a particular docket that is going to address juveniles who are tried as adults, because I want to know what's going on with them in the jail. How are they being treated? Is their mental health being addressed? That's how I'm going to address systematic racism. But as far as the people appearing before me, the judge himself is not responsible for that. That is on the charging agency. What I have to do and what I will do is make sure when people come before me, there's a level playing field.
Okay, Nandi, same question.
So the first thing I'm going to do is try to chip away of this kind of separation of duty, right? And so it's easy for judges to say, it's not my job, it's not my job. And so what I'm going to do is start open dialogue with the other shareholders in the criminal justice system, the police office, the DA's office, the sheriff's office. I want to know why. I want to start keeping data of who are being policed, right? Why am I getting defendants from a certain neighborhood all of time, right? It's not that I'm in charge of the individuals that are arrested, but I would sound the alarm if I find that I am finding out that a lot of my defendants are coming from a specific neighborhood, right? Because we know that certain neighborhoods in New Orleans are over-policed, right? And so I want to have conversations with the police office about how they're addressing how police officers are policing different neighborhoods. Then I also want to have an open dialogue with the district attorney's office about how they are accepting charges, right? And so no longer could we have systems that one arm is doing one thing, another arm is doing another, and we're not having conversations on the impact it's having on certain communities. That is how racism breeds, and that's how systems that are built on racism continue. And so in order to eliminate it, it has to be addressed. In order to address it, the shareholders in the criminal justice system have to have that dialogue. I understand that it's uncomfortable at times to have that dialogue. Judges are elected, and sometimes they don't want to talk about it because they fear that they're going to piss off electors or piss off voters. But if we are here to do the work, we have to talk about the underlying issue of racism in the criminal justice system.
Yes, and so on one issue in particular that has been raised in the news media, that is the fact that bail, fines, and fees make up a large portion of the court's budget. So do you support full public funding of the courts, partial funding of the courts, instead of relying so heavily on bail, fines, and fees? And we'll do this in reverse order, starting with Ms. Campbell.
So a user fund court is set up so that there'll always be users, right? And so we have a bloated system that counts on a certain amount of arrests and a certain amount of convictions, right? If you take that element out of it, then we begin the conversation of a system that is working towards a common goal and not having people need people to be in the system to fund it, right? And so the court kind of address this in taking away the conflict of taking fines and fees from defendants, but we didn't address by the statute, they didn't address the conflict of having indigent defenders or indigent defendants be the one who pays for their prosecution. Some people say that by saying that it's kind of like you're being a little crazy, you're being a little overwhelming, or you're exaggerating, Nandi, but currently, that's the way it is, right? And so if we have a city and state that says we have to have a robust criminal justice system, I believe we have a robust criminal justice system. I think we have a bloated criminal justice system. And if that is the state and the city, if that's their choice, then they should be the one who funds it, right? If we have a city and we know that the most people who use this program or come through this system is indigent, why would we rely on them paying fines and fees to keep it processed, right? And why do we have such a bloated system when we're not willing to pay for it? And when I say bloated, I mean, what's the purpose of having 13 judges, right? Why do we have 13 judges and 4 commissioners? Are we utilizing them? Are we paying too much into a system just to jail individuals? Why do we have such a large jail? Why are we incarcerating so many people? And then we get to the question, if this is the way we want it, why are we forcing these individuals to subsidize it? And so I believe that if we want a criminal justice system for everybody and we want it to be fair, then we cannot pay for it on the backs of our indigent and oppressed citizens.
Same question to you, Mr. Burns.
You want to restate it for me?
Yes.
I want to be
You know
specific.
that there's been many stories about the degree to which bail, fines, fees on defendants support the budget of the criminal courts. Would you be in favor of reducing that or eliminating that altogether and have full public funding of the courts?
I would be in favor of reducing it. I think that defendants who are charged and who are brought through criminal district court should have an interest in the funding of the criminal district court. This is something that not only goes on only in Orleans Parish, it goes on throughout the state. It goes on throughout the nation. When persons are charged with certain offenses, they are assessed fines. Those fines then go back into the system to help that system. It's not something that's criminal. It's not something that's racist. You know, and Mike, I want to speak to this point and I want to be brief. We cannot argue that something is racist simply because it's going on in an area that we know nothing about. It's going on in a culture that we don't understand. And we just assume we're going to ride in on this great white horse and solve everything and be everybody's savior. That's not the case. In this situation, again, that the responsibility of those in the system, it should be reduced, but they should have an interest in their fines and fees going to pay back that system that they take advantage of. A lot of people are appointed public defenders, but what you'll find is that those same people who are appointed public defenders, Mike, they've paid a bail bondsman to get out of jail. So where'd the money come for them to pay the bail bondsman? But then they come to court, they look at Judge Lyon Burns and say, Judge, I need you to give me an indigent attorney. Well, I can give you an indigent attorney. At this point, the courts are charging people $50 for a public defender, $50. If they were to go to some of these, well, let me point that, if they were to go to some people, that attorney certainly wouldn't charge them $50. They charge them 50 times $500 for their fee. So it's only a $50 cost that when people come to criminal district court, that they're charged by the court. Anybody would tell you that is not excessive. At a home, when you pay for a repairman, all service fees are going to exceed $50. But in criminal district court, A so-called indigent person can get the services of an attorney for only $50. I think that's a good deal. I think most people would take that deal.
Well, since you, brought up the issue of bail, let's move on to a bail question. We have seen the studies showing that in New Orleans, at any given time, perhaps as many as 1 in 3 pre-trial detainees remains locked up simply because of a inability to pay the bail that has been set. So starting with you, Ms. Campbell, what would you do to remedy that situation?
So there's a huge problem with individuals sitting on DA time, unable to make bond, and also having bond set an amount that's not based on anything other than what they're charged with. A lot of times, nonviolent crimes connected to possession of drugs or possession or charges connected to poverty or being indigent, right? And so I think the default, especially as it relates to crime of violence, should be ROR. That should be the default. And then we should work backwards, where the state should address why this person is a danger to the society and or why this person should not be let out because they have a history of missing court, right? And so I believe that that should be the policy for non-crime of violence, because we know that if somebody sits in jail on DA time, they're prone to lose their job, lose their house. Sometimes this individual might be the sole breadwinner of a household, and so the whole family is affected. And in Louisiana, unlike other states, the DA has a certain amount of time to accept the charges. And so I've seen this happen. I've seen this happen with individuals sitting, especially dangerous when an individual is sitting for a certain amount of time and then have the case refused, right? And so if you're sitting for 120 days and the case is refused, you just don't walk out and say, give me my job back or give me my house back. Now, in the case of violent crimes, we often have commissioners and judges just set the bond extremely high, right? You're charged with second-degree murder. I'm going to set the bond at $1 million without kind of delving into what kind of evidence the state have. And so what I believe is that when you're charged with a crime of violence, the commissioner should automatically set a preliminary hearing the day the bond is set, so that the substance of the case could be addressed and bond could be adjusted based on the substance of the case and the ties the individual have to the community, what kind of, if he is a danger to the community, has he missed court, do he have any priors, but they shouldn't have to sit in jail for 120 days if there's a possibility to let them out with certain conditions and report back to be heard. Another problem with having people sit in jail while the DA decides what to do with their case is expensive. It's expensive to house individuals. This DA time is costing the city a lot of money. And so we have to, once again, I'm gonna say it again, we have to address why we're spending all this money on a bloated criminal justice system. Time after time, I see individuals sit in jail for 2-3 years only to have their charges dismissed or win at trial. And it's not keeping the city safe, and we have to address why we're connecting bail with safety when there's no research that correlates the two.
Mr. Burns, same question to you.
One thing I want to make clear to those who are out there watching this program, with Lionel Burns as the judge in Criminal District Court Section G, no person charged with any violent offense, to include murder, will be allowed to sign themselves out of jail, or at no time will me as a judge think that it's more important that a murderer be back out on the street than it is for that person to have a reasonable bond and to spend some time incarcerated. Mike, if you've gone over to the Orleans Justice Center, the only people who are in jail now are people charged with violent offenses and people who have probation and parole holds. The jails have been empty because of COVID, because the sheriff does not want the responsibility. At this time today, no one is sitting in our jail because of an excessive bond. No one is sitting in our jail because their case has fallen by the wayside. We have hardworking judges who have looked into these cases. We have a hardworking magistrate commissioner who sets appropriate bonds. I support the bail system as it is today. Of course, there are changes that need to be made, but the bail bondsman assists the court and assists the criminal justice system. How do they do that? Because they have an interest. When a person is charged with an offense, they go out and hire a bail bondsman to assist them with making the bond. Who do I serve to come to court? When I set that case for arraignment, I serve the defendant himself, and I serve the bail bondsman, also known as the surety. So the bail bondsman has an interest in bringing that offender back to court. Mike, if I'm allowed people to just, when they want to get out of jail, come and pay the court $500, come and pay the court $1,000, that person's gonna leave and I'm never gonna see them again. But if we're just after money, I'm gonna have the money, but I'm not gonna have the person. I want the person to come to court and stand charges, face the community for the crime they're alleged to have committed. That is why in this town, in this criminal justice system, the bail bond system works. We cannot allow violent offenders to sign themselves out of jail. I'm not gonna do it.
Well, that is a hot button
I'll say
issue.
something.
Yes, I'm going to, ask follow-up questions of both of you on that.
Okay.
And then we can, maybe have you pose questions to each other. But let me just start with you, Ms. Burns. You say that, the jail has emptied aside from those booked in the most serious violent offenses.
And probation holds and parole holds. How do I know that, Mike? Because every single client of mine who doesn't have those issues were released when the pandemic struck. That's how I can tell you that, speaking from experience.
There has been a big push to, reduce the population of the jail for a variety of reasons, especially since the pandemic, but even before that. Nevertheless, people still go before the magistrate judge, the magistrate commissioners. A bail is set, and as we know, the revised statutes set out 10 criteria for which the commissioners and magistrate judges determine the appropriate bail. Now, we nevertheless see that some people, and perhaps it's because of, repeat offenses, repeat minor drug offenses, repeat, nonviolent crimes, in the eyes of a commissioner or the magistrate judge, do have a bail set. And that differs from commissioner to commissioner or commissioner to the judge. So is there any way to make that more uniform, to reform that in a way that nobody remains locked up pre-trial solely because of their inability to pay?
It's happening now, Mike. Every case that goes before a criminal district court judge at arraignment, the attorney has the police report at arraignment. They should have gotten the police report and met with the client over in the jail, and they bring that to the attention of the court. It was happening every day in criminal district court. Judge, this man has a very minor offense. Unfortunately, he's unable to make bail, but he has a drug problem. You know what'll happen, Mike? You ever heard of Odyssey House, that big building that they just built over there on Broad Street? The judge would release those persons to in-person treatment instead of allowing them to remain in jail. They would send them to O&M if they were homeless. No person is sitting in the jail simply because they cannot make bail on some low-level offense. Let's stop putting that facade out. Let's stop that here today, making people think that some unfortunate person or there's a tier of unfortunate poor people sitting in the jail who can't make bond. That is not the case. The people who are in the jail now, murderers, rapists, the people who need to be there, and people who have issues with probation and parole. Go to the jail and see that, Mike. I have all of my clients who don't have those issues. The judges were gracious enough to release them. And as a judge, I'm going to be gracious enough to do that as well. But the violent offenders, no, sir, it's not going to happen. I won't do it. Because when you talk about those 10 factors, one of those factors is what, Mike? Dangerousness to the community. In New Orleans, what is the dangerousness to the community of releasing these people? I can tell my opponent, that's why they get $1 million bond. That's why they get a $2 million bond, because they've taken somebody's life and they're a danger to the community. We don't want them to come out and murder again, as we have found has happened. Women are being murdered. Children are being shot in their bed. Little girls are being raped on their way to school. I want those persons to stay in the jail. Read my lips. With Lyon Burns as judge, they're going to remain there. I'm not going to let out rapists and murderers. It's not going to happen.
Okay, Ms. Campbell, I think you have some things to say, both to address the follow-up question as well as the statement by Mr. Burns.
So what's dangerous to this community is to have a potential judge not understand that people are innocent until proven guilty. That's dangerous to the community. And also, I want to thank the Public Defender's Office, because Mr. Burns believes that they opened the gates during COVID and just let all of the nonviolent people up. And I know that the beginning of COVID, that the Public Defender's Office and some partners went on a spree to raise money to bond a lot of these people up. But as a judge, I can't just think about what goes on in COVID. I have to think about the process. I have to think about what happens in the future. It'll be nice to sit here and have a forum to talk about what's happening now in the special circumstances. So kudos to the judges who address individuals who are in jail because we have a COVID situation. But when I'm talking about bail and I'm talking about bail reform, I am talking about a system. I'm talking about long-term reform and the impact it has on not only defendants, but their family. Make no mistake that there's no way in the world that I said that people who are charged with murders get ROR. That is not what I said, and I want to make that perfectly clear, because I'm sure Mr. Burns understands that in a statute that cannot happen. What I said was we can't treat each case the same. And I've had individuals sit in jail for a year on murder charge and had them dismissed, refused. And so an innocent person should not have to sit in jail because they weren't born uptown on St. Charles and they're charged with very serious crime. They should get a bond that correlates to the charge, that correlates to the evidence, that correlates to their priors, that correlates to their ability to be released and keep the community safe based on their income and their circumstance. We have to get away from this one-size-fits-all system. And so what I am saying is, as it relates to bail, if you're charged with a nonviolent crime outside of the COVID era, the default should be ROR. And if you're charged with a crime of violence, automatically that commissioner should set a preliminary hearing so we can discuss the evidence, because individuals like my 17-year-old client should not have to sit in jail with adults for 3 years to have a not guilty and lose 3 years of his life because his parents couldn't afford a bond.
Okay, well, it's going on 6:30. It's the point when we can start to open up the forum to questions from any of the people viewing. And we have one question right now, which is, and it kind of make this into two parts, but let's start with wrongful convictions. Unfortunately for this jurisdiction, New Orleans, we have some of the highest rates of wrongful convictions going back many decades. And what can an elected judge do to A, prevent that, and B, to hold prosecutors accountable so that those grave mistakes don't happen again? Let's start with Ms. Campbell.
So first of all, to prevent it, we have to have a conversation with the DA's office about what's the culture in the office. If you have a DA's office where the culture is to count the number of cases you tried and count your win rate, then more than likely that is their priority. And when that happens, what happens is guilty people walk out on the streets. Innocent people go to jail. Because if the DA's prime goal is to win at all costs, then people's rights are going to be trampled. So if you understand that the DA is not having this environment, he's not having a culture of, we are here to disperse justice, not to win cases, then that's a conversation that needs to be had with the office, and a judge needs to ensure that that culture is changing over there. Holding people accountable, I feel like we need to get out of this immunity system as it relates to DAs and as it relates to police officers. I think too many times the DAs use that as a shield for bad behavior, right? And so if you're a DA and your goal is to win many cases, so down could count your win rates and how many cases you had, then your behavior is going to be connected to that. And if you're found to not have, not give evidence or withhold evidence or plant evidence, and you're not prosecuted, then the behavior is not changed, right? And the person who comes after you might do the same thing because they don't see you being prosecuted for it. They don't see you being punished for it. And so we have to address the fact that the DAs are working or practicing in this cloak of, I have immunity so I can run rampant. As a judge, I'm gonna call it out. I'm gonna call it out. I cannot be in a position where I am judge and I see that somebody's constitutional rights is being trampled over because a DA wants to win at all costs. And so there's also part of my platform where I talk about sentencing review, because I know I'm not the first judge in Section G. And so if an individual down the line feel like they got a bad rap, or they had a DA who was overzealous or overly aggressive, I want to talk about it. I want to talk about the 17-year-old kid who got 50 years on his first felony charge and now is still in jail and he's on year 26, 25. I want to talk about, is it possible that he's ready to return back into the system because he was convicted under this oppressive DA's office? And so if we're talking about reform, we have to address the sins of the past also.
Mr. Burns, same question.
There's a case that occurred in Section G. A young man was charged with armed robbery. It was his first offense. The Honorable Judge Julian A. Parker sentenced the young man to 99 years. His name is Alden Morgan. Judge Julian A. Parker. And to participate in this forum tonight, you know, I would hope that we would begin to be just a little bit more genuine and not so disingenuous, and say that we're going to do things that we know the Constitution does not allow. A judge cannot have a sentencing review simply because there are laws that apply with post-conviction relief. Let's stop acting, Mike, like the judge is going to be the district attorney, the state legislature, the jailer, the bail bondsman, the magistrate commissioner, the jury, the sentencing reviewer. That's not the role of a criminal district court judge. Let's be very, very clear about that. Have mistakes been made in the Orleans Parish District Attorney's Office, where I'm very proud to have worked? Mike, you know, most of the judges who sit in criminal district court today are former assistant district attorneys. And because, let's see, I point this way, because some people are not from here, they don't know the history of that office and the many hard hours we put in at that office for a very little bit of money. But we didn't do it for the money. We did it because we loved our community. We were from the community. And my story, as a Black prosecutor, it made me proud. As a Black prosecutor, I was able to know that when Lionel Lyon Burns had someone convicted and found guilty as charged of murder, rape, of drug dealing, I could say that I served proudly as a prosecutor on that case, and that person at the end of the day got exactly what they deserved. No one was cheating. No one was planting evidence. Mike, what do we have today? We have a consent decree with our police department because it was discovered that evidentiary issues didn't happen in the DA's office. They happened where, Mike? Through whom?
I see your point.
Through the New
And-
Orleans Police Department. We want to have a discussion and a dialogue, right?
Right.
It
Well,
happened
let me
through
just
the
take this,
New Orleans Police Department. It didn't happen through the district attorney's office. So for anyone to sit here and disgrace all the fine men and women who have served as district attorney, all of us who are former assistant district attorneys, to sit here and disparage and disgrace us is very disingenuous. Please stop it. Please stop it.
Good. And, this is an important question. Once again, I'll go to the premise of my previous question, which is this jurisdiction, Orleans Parish, has a poor track record. Many people have done many decades cumulatively behind bars for crimes they did not commit. Now, we hope that reforms, a police consent decree,
Yes, sir.
is preventing this from
Yes, sir.
happening going forward. But we still have cases working their way through the courts on various stages of post-conviction relief, in which people have claimed that, whether it's Brady evidence being withheld or simply science has caught up with DNA technology now being available. What would you do as a judge for some of those lingering cases which continue to work their way through the court? I'm not talking about present day allegations of police misconduct, but current cases continuing to work their way through the courts of claims, let's just say credible claims of wrongful conviction. We'll start with you, Mr. Burns.
Well, Mike, I must tell you the canons prohibit me to tell you exactly how I would rule on something that may come before me. The canons prohibit that. But what I will tell you, what I will do with any case, I will listen to the facts and the evidence as they come out in court, not in the newspaper or on the courthouse steps, but as they come out in the court. I will weigh the evidence. I will look at the law, and with God's grace, I will make the appropriate decision. Were people wronged in the past? Yes. Were people wrongly convicted? Yes. Did police officers make mistakes? Yes. Did police officers commit crimes to have persons incarcerated? Yes. And as judge, if that's the case, if that is shown, I'll deal with those cases appropriately. But at this point tonight, I don't want to tip my hand as to have to forfeit my being able to sit when I'm elected in such cases, because someone reports that at one point or another, I said I would rule on these type of cases like this. So I'm going to try to answer that question as I have as best I could.
Well, I have to, just add my own little commentary as a journalist that thank goodness, for the media being a fourth estate, an additional watchdog, where some facts can be brought out that eventually leads to these successful claims of exoneration. I'm going to pose the question to you, Ms. Campbell. Once again, let's just presume that the reforms that are taking root through a consent decree of the police department, and obviously strong attention on district attorneys, complying with Brady. What can be done about some of those older cases with credible claims of innocence?
So before I answer that, it's important that I say two things. One, if a defendant was sentenced without a plea agreement between the defendant and the state, a judge absolutely could review his sentence because it's the judge's sentence. So I just want to make note of that. Two, when you talk about credible claims, I think that no matter if you were the judge, you should always hear or be open to hear credible claims, especially since we know that we are the most incarcerated. We're also the most exonerated, exonerees, New Orleans, right? And so we have to not put our blinders on and act like there wasn't a culture where it was win all. I'm not disparaging all district attorneys, but we know by evidence, by people who are walking out of jail right now after serving 20, 25 years, that the checks and balances wasn't in place. So it's really nice to be like sitting here and say, oh, the police officers did it. The police officers missed the evidence. But the reason the DA is there, they're supposed to check the police officer's work before they take a case to trial, right? And so you come to this issue where the DAs are ignoring the problem cases, they're ignoring the lack of evidence, they're ignoring the sloppy work and still pushing a case to trial. I represented Jerome Morgan with the Innocence Project once he was granted a new trial. And I was horrified to read his transcript. He had a murder trial that lasted 1 day. And the judge on his case is our current DA. And I remember crying, thinking to myself, like, who wouldn't have stopped this travesty? Like, who wouldn't have said there is something wrong about trying a 17-year-old in a 1-day murder case? And so what I'm talking about is checks and balances. I'm talking about accountability. And until individuals are willing to say, look, I messed up, I got wrapped up in a culture of win, 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 I might have had an impact on some convictions, then we're going to continue to do this. We're going to continue having DA offices where individuals are pushed to that win-win attitude, right? So as judges, we have to be open to listen to credible requests to open their case. And it's not about saying what you would do, but we have to be open to listen. And that's part of our job. Part of our job is to review that everybody did their job right. And since we have evidence that we had a time period where certain people were not doing their job and it resulted into like prosecutorial misconduct convictions where we have individuals walking out of jail today after serving 20, 24 years, we need to be open to hearing those claims. And I hope the
Very
new
good.
is finding a way to do that.
Okay, now we're reaching the kind of the tail end of our forum. So we're going to go very quickly to sort of a lightning round, give a quick yes or no, and an explanation for your reason for yes or no. Starting with Conviction Integrity Unit, there has been failed attempts by the district attorney, Innocence Project, and defense attorneys to get together and review some of these cases in a Conviction Integrity Unit. They have not gotten off the ground. Is there any role for a judge to play in fostering a Conviction Integrity Unit, starting with you, Ms. Campbell?
You said Mr. Campbell. Yes, I think
I'm sorry, I said Ms. Campbell. Ms. Campbell.
there's a role because once they review the case, it's going to come back to the section. And so I think that if the DA is open to having a conversation about it, I think that judges and DAs need to get together to identify some of these convictions that need to be reviewed. Also, some of the sentencing that need to be reviewed, right? There was a law and order crusade 20, 30 years ago. I believe we need to go back. We need to review those cases that Mr. Burns talked about when an individual is given 99 years. There is the law that says we can do it if it wasn't part of a plea agreement. So I think the judge's role is to kind of push the DA to say, let's do this in combination so that we ensure that going forward, we're kind of saying that we want to do things right, both the DA's office and the judges. And so we're in unison to make sure that individuals' rights are protected.
Mr. Burns, Conviction Integrity Unit, is there a role for judges to foster such a thing?
Mike, you know, when I ran for district attorney 6 years ago, that was one of my platforms to create that very unit. The district attorney started it and it lasted probably about a month because they couldn't get along. As a judge, of course, I don't want to do the DA's job. Remember, I told you, I want to be the criminal court judge. I don't want to be the DA, the sheriff, the clerk of court. But as a stakeholder in criminal justice in New Orleans, I would encourage all sides to work together. I think Emily Maw in Project Innocence does a great job. I would love to see her work together with the district attorney's office. But remember, there's a separation of powers that exists between the judiciary and the district attorney's office. And I want to keep that bright line there. But I would encourage all stakeholders to work good for who? For the good of the New Orleans community. And I'm going to use my position as judge to see that that happens. But will we all be in bed together? Will we all work in concert together? Absolutely not. The district attorney is the prosecutor, Project Innocence, or the fact finders after someone is convicted. And as judge, I sit as the referee.
Very good. All right, another lightning round question. I'm sure both of you veterans of Tulane Abroad are familiar with the city's Safety and Justice Challenge. It's a MacArthur grant where they have put up money for programs to reduce the number of pretrial detainees, lower the jail population. Is there a role for judges in continuing to make progress under the Safety and Justice Challenge, starting with you, Mr. Burns?
Yes. As a judge, remember what I'm going to do. I'm going to always review their work. I'm going to always review the recommendations that they make specifically with mine. So that is going to be my role. And as a judge, everything that happens in Section G is going to have my stamp on it. When somebody has had a bond set by the magistrate, I'm going to review that bond to determine the appropriateness. And remember, Mike, and to everyone under the sound of my voice or who can see me on video, I'm going to examine that person's dangerousness to the community. That's going to be the most important thing. And then I'll look at their criminal record, whether or not they're going to reoffend. Those are things that are very, very important to me. Why is that important to me? Because as a criminal defense attorney, I've worked both sides of the aisle, and I've represented people who were charged with committing crimes. And one thing we do as defense attorneys, most of the people we represent plead guilty. They don't walk out of court innocent. We don't prove them innocent. We plead them guilty. So again, let's not sit here and act disingenuous as if we're representing all these innocent people who are coming to court. Most people come to criminal district court and they plead guilty.
All right, same question for you, Ms. Campbell, the MacArthur Safety and Justice Challenge. Is there a role for judges to play?
So first of all, we do represent innocent people because you're innocent until proven guilty. So up until the time my client take a plea, they're an innocent person. And so
like Darren Sharper.
The foundation of the criminal justice system and the constitutional rights of the criminal justice system needs to be important to a judge. And so as it relates to the Safety and Justice Challenge, I think that it's the tools that they provided is very useful. The risk assessment is a great tool, and I think that works side by side with my theory of that the default should be ROR for nonviolent crimes. Also, the diversion or to divert folks with addiction and mental illness so that we are not sort of like subbing as a hospital, right? And I feel like judges need to identify that even if lawyers can't, we have to be in a situation where we're not spending time and attention and money when we can identify that this person needs medical care. Not medical care in a jail facility or monitoring in a court facility, but actual care that goes to addiction and also mental health. Being transparent with charge time, process time of cases, but being transparent with the process of a case in a way that we're not rushing people through just for the sake of saying we completed this case in a fast manner. So what I appreciate about the Safety and Justice Challenge is the transparency and the conversation about how we can improve the system as a whole, especially as it relates to having individuals languish in jail while they're going through the system. And it's really kind of jarring because individuals are innocent until proven guilty. And so we want to be cognizant of the fact that there's a possibility that we're reducing their success rate for returning back to society just by having them languish in jail.
Very good. And I see that we're winding down. So in sort of the form of a last question along with your closing statement, we know that judges have been called sort of the referees of court, call balls and strikes, neutral right down the middle. So what would differentiate you from any of the other judges sitting on the bench now, we'll start with you. Mr. Burns, what sets you apart? And think of this as your closing statement.
The thing that would set Lionel Lyon Burns apart from any other judge that currently sits on criminal district court is I have tried 167 jury trials. No judge currently sitting in the court has my trial record. When I was at the district attorney's office, I had a 97% conviction rate. As an attorney in private practice, no judge represented anyone to the extent of Natasha Allen, who had a federal case that was brought against the New Orleans Police Department and the city of New Orleans, or represented someone to the level of Chelsea Thornton, a mother charged with 2 counts of first-degree murder, who I had to get into court and plead with the judge to find her not guilty by reason of insanity. No judge has worked as a social worker with Volunteers of America. I worked with homeless people. That's why it's so important when you hear me say, I'm from New Orleans. I'm born and raised. I have a commitment to the community. I have a commitment to the people in the community to keep our neighborhoods and our families safe. I'm going to be tough on crime, Mike, but I'm going to be firm and I'm going to be fair with people. That's going to be the big difference about me. But every time that I take that bench at criminal district court, at Tulane and Broad, I'll know that I have an entire community behind me, an entire community that I have to protect. One thing you know about me, and I think I've known you a while, simply from you doing reporting, Lyon Burns, folks, is not a politician. I'm not somebody who aspires for public office. I'm not out kissing babies and making deals, but I am an attorney. I've worked both sides of the aisle, and I'm to the point where I'm ready to ascend to the bench to allow the public to benefit from my experience, from my legal expertise. And that's why I have offered myself up for public service. Lionel Lyon Burns, number 91, Criminal District Court, Section G. Experience matters. Thank you,
All right,
Mike.
Ms. Campbell, same question to you. What would set you apart as a criminal court judge?
So the first thing that's going to set me apart is before going to law school at age 33, I was in business management. So my business management background is something that no judge has, right? And so I'm going to use that business management background to ensure that the city of New Orleans is going to get a judge that's really efficient as it relates to human resources, how we utilize the workers in the court, and also how do we utilize time of our police officers, time of our district attorneys, time of our public defenders, how we allot our funds. And so prior to going to law school, that was my specialty. I was an operation manager, so I bring that there. Also what I bring is passion, right? I went to law school at 33, not to become a lawyer, but because I was passionate about the criminal justice system and what was happening in this country. And so after 12 years of working in my community, because I made a decision to move to New Orleans, I live with the people I represent in the middle of Central City. And so although some believe that you can't be passionate about a community if you move here and not born here, I beg to disagree with that. And so what I bring to the bench is my understanding of how a system works and what we can do better, based on my experience in the courtroom, based on teaching at Tulane Law, based on teaching at Loyola Law, based on my experience on the CJA panel in federal court, based on my experience as being a conflict attorney at Orleans Parish Public Defender's Office, and based on my work with Innocence Project, and based on my relationships with high school students, college students, law students in my mentoring program. And so I bring all of these relationships, all of these connections to the bench to ensure that individual rights are protected while we have a safe city. And so I'm asking you that you need to vote for me because I bring quality over quantity. I don't know how many cases I tried because it's not about the number, it's about the individual with me. Thank you.
Very good. And I see, we run out of time. That wraps us up. I would like, of course, to thank our hosts, all of the great organizations involved in putting on this and other forums.
Thank you.
And especially our two candidates for taking time. I know this won't be the last opportunity, but especially to all those who have looked in on this very important element of, the election process. This is a race with 2 candidates. There will be no runoff. So the message for everybody on all sides, please get out and vote. This Section G race will be decided with the primary. So once again, thanks to everybody, and on to the next forum.
Thanks, Mike.
Thank you, Liz. Thank you, Mike. Thank you, admin.
Thank you, everyone. Our next forum is going to be starting in just a few moments. It's going to be Section K. So take that bathroom break and then come back in just a few minutes. Thanks.